Very well, very well. Thank you.
Yeah, it's possible. So I think it's going to 8:40. So we'll pray, then we'll begin. Let me choose someone to pray for us. Since Sarah C. Hoya has graciously agreed to project for us, I'll ask Alice Karaoke kindly pray for us, then we can begin. Alice Karaoke, are you in the meeting? I think we lost her anyway. I think then I'll offer to pray, then we can begin. Let's pray. Dear Lord in heaven, we come before you. We thank and we bless you. Thank you for this beautiful night that we are here to discuss criminal litigation. May you give us the focus that we need. May you bless us with all the equipments that we need to understand and also just to be able to address the questions adequately. We ask for your favor, dear Lord. We ask for peace. Even as we study, we ask for calmness. May you hush our anxieties and may you bless us, dear Lord. You remember the class of 2023 as they prepare for their exams. And above all, dear Lord, may it end in praise to the honor and glory of your name. This is our prayer of faith through Christ, our Lord and Savior. Amen.
Amen.
So, yeah. So welcome to today's session, which is criminal litigation. Hamduni Angelo and I will take you through the revision. Please, at this juncture, I just want to welcome and tell you guys that please raise any questions that you might have. Please don't feel shy. This is a platform to learn and to understand and to help each other. So please use this platform to help you also understand where you might not have understood while you were in class. So we'll begin. And Angelo, I don't know how you guys do it. Do they read the questions or how do we do it? Angelo?
Yes, come up again.
I'm saying, do they read the questions then we discuss, or how do we do it? Like from the first one as we proceed, or yeah?
Yes, we will begin with number one, whereby someone from the group will read.
Okay.
Thereafter, we will hear responses from our colleagues.
Mm-hmm.
And then you will proceed to give your views or your position or what the correct answer is.
Mm-hmm.
Yes.
That's in order. Thank you for that.
Move like that one, yeah. So, and our agenda is to try to finish to complete the question within the time frame that we have.
Okay. And also, thanks for that. And just to also remind all of us, please, as we have these sessions, also see how you can, how do you put it? Because remember, CLE is about speed. You might have answers to everything, but if you're not strategic when it comes to time, you might not finish the paper. Okay, not everyone finishes the paper, but we still passed. But it's good just to, at the end of the day, you know you gave it your best and you're able to give the answer short and precise, or even if it's detailed, it's straight to the point. So also have that as a technique today. Even as you hear the answers from your colleagues, try see how well you can be not really economical with the answers, but economical with time, because time is money. Yeah. Anyway, so I'll ask one of you to volunteer and read for us question one. Anyone?
I think I can read. My name is Ochieng.
Thank you, Ochieng. Go ahead.
Okay. On 24th of January 2015, Honorable Mwamburi Mwanzo and another were arraigned before the Chief Magistrates Court at Mutongwe Law Courts, where they were jointly charged with two offences in Count 1 and Count 2. In Count 1, the two are jointly charged with the offence of creating disturbance contrary to Section 95(1)(b) of the Penal Code. The particulars of the offence were stated as follows. On 24th day of January 2015 at about 8:30 a.m. at Nisi Center in Mutongwe within Mombasa County jointly created disturbance by shouting and uttering abusive words at PC Mwamba while demanding release of motor vehicle KMCH002B, which had been impounded by PC Mwamba for failure to comply with traffic rules. In count 2, both accused persons were jointly charged with the offense of intimidation, contrary to section 238(1) of the Penal Code. The particulars of the charge were stated as follows. On 24th day of January 2015, at about 8:30 a.m. at Nisi Center in Mutongwe within Mombasa County, jointly intimidated PPC Mwamba, a duty officer at Nisi Patrol Base, by invoking the name of senior government officers with the intention of causing him to release motor vehicle KMCH002B, which had been impounded for failure to comply with traffic rules. The accused persons pleaded not guilty to both charges. The two were released on cash bail pending the hearing and determination of the case. 2 weeks later, a pre-trial conference was conducted and the case was set for hearing. The prosecuting counsel indicated to the court and to the defense that he intended to call 15 witnesses during the trial. The trial process began in June 2015 before Honorable TGG, who was then Senior Principal Magistrate. Honorable TGG had the evidence of 7 witnesses, while the 8th prosecution witness was stood down. Honorable TG was then transferred before the completion of the case. Before Honorable TGG was transferred, the prosecution had applied to the court to introduce a CD containing a video of the incident in question, which was taken by an iPhone belonging to prosecution witness 8. Which iPhone could not be traced for production in court. The application was opposed by the defense. The trial court disallowed the playing of the subject CD without a certificate as prescribed under section 106B of the Evidence Act. On 13th February 2020, the Honorable KBB Chief Magistrate took over the case. The prosecution recalled prosecution witness number 8 and applied once more to rely on the CD as they complied with the requirements under the Evidence Act. The application was allowed on the basis that the prosecution unveiled the certificate as required. As dissatisfied with the ruling of the court, the defense filed an appeal in the High Court on various grounds. While the criminal appeal was pending, the defense filed an application for stay of proceedings. The application was filed under certificate of urgency. It was heard ex parte and a stay order issued. The appeal was heard and determined in June 2022. At this point, Honorable KBB had been transferred and the case was taken over by Honorable JL, Chief Magistrate, who had the remaining 8 witnesses and both accused persons placed on their defense. The accused persons once again appealed the ruling of the court on the basis that the prosecution had not established a prima facie case against them. While the appeal was pending before the High Court, Honorable JLL was transferred. On 20th December 2022, the Deputy President of the Republic of Kenya made a statement on the national television that all criminal cases where accused persons had been charged unfairly should be withdrawn. This statement prompted the second accused person to write a letter to the Director of Prosecution requesting for review of the evidence, and particularly that she was willing to plead again. The appeal is yet to be heard and determined. The prosecuting counsel requested the court for type proceedings, and upon perusal, he discovered that none of the 2 trial magistrates, Honorable KBB and Honorable JLL, complied with the law requiring the court to inform the accused of their right to recall witnesses or to hear the case. Question 1. Discuss 5 criminal trial procedural issues the prosecution counsel encountered in this case. Part 2, discuss 5 procedural safeguards that have been put in place to protect and support vulnerable witnesses and offenders.
Thank you very much.
Okay.
No, before we go to answering the 2 questions, this is just a hack I also want to tell us. Sometimes in the exam room, we might really find a long scenario and you're clearly wondering, do I have to, not just to say that you need to be lazy, but another way of, remember we're also trying to be economical, yeah? Another way of, with time, not with answer, but with time. Another way of being strategic and being able to finish the exam in good time and ensure at least you've answered or attempted most, if not all, the questions. You can always go to the question before you read the scenario and try to get really what they require. Because now if you had just gone to read the two questions, at least in your mind, you will be telling yourself, oh, so as I read, I need to look out for procedural issues at stake, and I need to kind of think about the procedural safeguards that have been put in place to ensure that vulnerable witnesses and offenders are their rights are protected. So another hack is always, if you get a question that has a long scenario, always go to the question. It somehow guides you on what you need to look out to. You're not just reading blindly, especially if you've only done the 5 questions, the other 4 questions, and time is limited. And you, of course, you know, if you fail to do question 1, you'll be penalized. So it's also a way of you trying to be economical with time and ensuring that you at least attempt all the questions. Anyway, without any much ado, anyone who wants to attempt, or anyone who their thoughts on question 1, and 1, 2, anyone? Maybe we can start with 1 first. The floor is yours. Remember, the more you talk, the more you're able to be corrected, and the more you at least know if you're on the right track or, yeah. So the more you talk, the more you understand. Yeah. And remember also, when you keep quiet, you're also denying the others a chance to learn from you. And also you're denying yourself the chance to express yourself and be able to see if you're on the right track. So the ball is in your courts. Please, anyone? I'm not sure if someone has raised their hand. Anyone, please? Guys, rather, ladies and gentlemen. Yeah. Rather, let me even make sure I'm being heard. I hope I'm being heard.
Yes, we can hear you.
Okay, sorry. I've heard someone talking.
I was saying we can hear you.
Hi, how are you,
Okay.
Danga?
I'm fine.
Yes, I can give the first one that I've seen.
Yeah, your name, please. Sorry, I'm using my phone. Is it Pius?
Yes.
Go ahead, please. Thank you.
So the first one is plea bargain. So this would fall under section 137A, the Criminal Procedure Code. So there is a point here where the Deputy President of the Republic of Kenya made a statement on the national television that all criminal cases where accused persons had been charged unfairly should be withdrawn. So this statement prompted the second accused person to write a letter to the DPP requesting for review of the evidence, and particularly that she was willing to plea bargain. So that is a procedure. That is an issue in the trial process that normally happens. So that is the first one that we'll talk about. So I'll yield the floor for other students to also come up with others. Thank you.
Okay, thank you for that. Before I even comment on the plea again, I also want to know the other, so the question says discuss 5 criminal trial procedural issues. Onyango has just given us 1. So kindly, colleagues, please give the other 4, then we can now discuss them together and see which one makes sense, which one does not make sense, or where we need to improve. So,
Rispa, we have 2 people. We have 2 persons. Akumu Onyango and then Muhindi Charity. So Akumu should go first and then Muhindi.
Yes, in that order. Thank you.
Okay, confirm you can hear me, Rispa.
Yes, I can.
Okay, so I can identify two issues. One of them being that from the set of facts, we have been told that the minister released a statement that all persons should be, a statement to the effect that their cases need to be withdrawn. So I find that there is an issue in that particular statement because it's only the DPP that has the power to withdraw a case. So there is no way a minister can release a statement that person should be released or acquitted. It's only the DPP who has the power to withdraw a case or enter the nolle prosequi. So that is one of the issues that I've identified. And then another issue is that the person they were claiming that the prosecution did not satisfy a prima facie case, and now they want to appeal on the same. But we have not been told whether they filed their defense and proceeded to defend themselves. So an issue that I find to lie there is that when the prosecution has failed to enter to satisfy a prima facie case, then the court will rule to the effect that the prosecution has not satisfied the prima facie case, and now the case will probably not proceed. And in the event that you are dissatisfied, you have the option of filing a defense and defending yourself after the court enters a ruling on the same. So those are the two issues that I've identified. On the second issue, then they cannot appeal on the same if they have not yet filed a defense or defended themselves as per the procedure in the criminal litigation trial process. Those are the two issues that I can identify.
Thank you very much. Your colleague, kindly, the floor is yours. Give us the remaining two or even others.
Okay. The first one I can identify is the instance under section 200, subsection 3 of the Criminal Procedure Code, where the prosecution recalled their witnesses, but the judge failed to inform the accused of their right to cross-examine those witnesses again. This was held in the case of Peter Ndegwa versus Republic. That particular failure of the judge to tell the accused persons once a witness has been recalled, it usually amounts to a mistrial. And then another one, in the instances where a witness has been stood down, when they are recalled again to the stand, to take the stand, they have to be reminded that they're giving evidence under oath, and that did not happen in our case scenario. The other one, which maybe others can help with it, is the admission of electronic evidence through a certificate. Yes, and the other one is stay of proceedings. In the instances where the previous speaker has spoken about it, in the instances of an interlocutory appeal where it's not usually allowed. So in that instance, can you also stay proceedings? Can that now amount to a procedural issue? Thank you. That's all I did.
Thank you very much. I see Hilary Adwar, your hand is up. Do you want to say something before we can comment on what your colleagues have said?
They've said what I wanted to say, especially on interlocutory proceedings, that there's a section on at Criminal Procedure Code that talks about interlocutory proceedings, so it's disallowed. Let me look for it and then I'll contribute more on that.
Thank you. We've charged you with that burden. Please look for it and get back to us on the issue of interlocutory proceedings and how they are not, whatever the idea you want to put across. I see Sorry, I'm using my phone. I don't know whose else hand is up.
My hand is up, Council. I can go, right?
Yes, you can go, Bwana Eko.
Thank you. Thank you. I think I looked at this question in the past just to understand it, and I had come up with a myriad or a barrage of issues, and some which have been, I think, spoken about. My prima facie look at the question, I saw issues to do with disclosure of evidence, plea taking, probably issues of part hard cases. I also saw issues on probably unnecessary adjournments, probably also a question of protection of vulnerable witnesses. But I think what I can say for now is the issue of the victim protection, which I went and checked about the Victim Protection Act. I was interacting with it actually for the first time, and I realized it's giving effect to Article 59 of the Constitution. And Article 59, basically, it was giving effect to the Article 59 of the Constitution. I don't have my Constitution here, I would have read it verbatim. But the Act, I think, came in to protect, to provide for protection of victims, especially during trials, and where they are likely to be vulnerable in some cases. And I see in this case, there could be an issue that touches on the protection of victims during criminal trial. I think that's what I wanted to add. Thank you.
Thank you very much. Sorry for that. I was trying to unmute. Thank you very much for that, Bernard. So now I want us to discuss what, and please feel free to chip in, and we'll do this a bit fast. So your colleagues mentioned issues around plea bargain, withdrawal of cases. The prosecution also has failed to satisfy a prima facie case. The issue of the accused person not being given a chance to recall or even cross-examine these recalled witnesses by the prosecution, and also the admission of electronic evidence, and also a question of the stay of proceedings. It depends with how you want to put them. But just to begin with, I think also it's good for us to understand where this question, what this question was testing, just not giving answers, but also understand which maybe topic that was coming from. I think from what I thought, or even when I was handling the exam, I thought this question it came from the whole question of trial process in criminal procedure. So once you understood the trial process, you'll be able to know where the shortcomings of this scenario were, or rather even the challenges, or even the key issues which were faced in this scenario. Also, I want to say that the answers given, they're not wrong, they're actually correct. And first of all, I'll begin with plea bargain. Even as you look at the whole question of plea bargain, understand what is plea bargain, who initiates plea bargain, what is the effect of plea bargain, what kind of cases are not amenable to plea bargain, yeah? What kind of cases? Okay, yeah, are not amenable, not the effect of plea bargain, yeah? So please understand the whole procedure. And how plea bargain came up here. Bernard, I see your hand is still up. I don't know if you want to say something.
Sorry, let me bring it down, Council. Apologies.
No worries, not at all. Anyway, so please look at the whole question of plea bargain and how it came up. The number two, the withdrawal of cases. I had one of your colleagues saying that it's not the function. Such is a prosecutorial power, and it lies with the prosecutor to either withdraw, which is to enter another prosecute, and such only power belongs to the DPP, or rather the office of the DPP. So again, that was an issue at stake here, because I think it was, if I'm not wrong, it was, I think, a police or someone who was trying to have those cases withdrawn. Yeah, I can't recall the facts very well anyway. So there's also the whole question of withdrawal of cases. Then number 3, which is very, very important. I was writing down your answers, so I want to comment on each of them. I think it was easily identified, or rather somebody could easily tell that if a prosecution, this one I know, I hope you know by now, if the prosecution fails to, first of all, the court is normally required after the prosecution gives, it calls its witnesses, and the court is now required to make a ruling to see whether a prima facie case has been met, or rather, a prima facie case has been established. So if the court says that a prima facie case has not been met, it means the accused person will be acquitted. Yeah. But if the court is to find that a prima facie case has been met, the accused is now put on the defense, where they have all those 3 options that you know in the Criminal Procedure Code. So in this scenario, I think the accused persons were appealing, and they were saying that they're appealing the ruling of the court on the basis that the prosecution had not established a prima facie case. So I think it's important for you to raise to comment on this issue of prima facie case. That can you really appeal on the court's ruling that a prima facie case has not been met? Yeah. And again, you need to understand the effect. If a prima facie case has been met, what does it mean? If there is no, if the prima facie case has not been established, it's quickly means that the accused person will be acquitted. So again, can you really appeal on such a ruling by the court? Also look at that and what the law says on that. Then number 4, there's the issue of recalling of witnesses. But the court, I like what your colleague cited, the case of Peter Dego versus Republic, and there was where the court said that, it was held that the court is under duty to explain to the accused person that they have a right to recall their own witnesses, as well as cross-examine witnesses who have been recalled by the prosecution. Because again, failure to do so will amount to a miscarriage of justice or even mistrial. Yeah, that is also key here. Number 4 is on the issue of sorry, I've just seen something. The issue of withdrawal. The one who wanted to withdraw those cases is the deputy president, the police. Sorry, the withdrawal is only rests with the DPP or the ODPP. So also is the whole question of admission of electronic evidence. Please look at what the law says on that there has to be authentication and authenticating certificate, something of the sort. Look at what the law says on that. Then lastly is on the issue of stay of proceedings, especially interlocutory proceedings. I think our colleague, I forget his name, please shoot your answer. We are happy to hear what you found so that we can proceed to the next question. I can't recall your name. Yes, I just remember. Sorry?
Okay, my hand is up, but I'm not sure whether I'm the one you're talking about.
What do you want to tell us? We are happy to hear also from you.
Oh, yes, I just wanted to contribute. Maybe I see a case of unreasonable delay in this criminal trial, which might affect the right of this person. It's a violation of the rights, because I'm seeing, if you count from when they started, it's quite a bit long. I know in Kenya, I understand there is no really a law on how long it should take, but if you look at jurisprudence from Canada, which have been cited in most of our cases in Kenya. You find that there's a rebuttable presumption of unreasonable delay, which if accused goes for more than 18 months, then it's considered unreasonable delay. You'd find those in cases like Jordan versus Republic. That's a Canadian case, and it's cited in one of Kenyan cases, Charu Karisa Salimu versus Republic, where in Kenya, the practice is now for judicial officers to have performance contracting that actually spells out how long a case should take. So I'm thinking that it was unreasonable delay in this particular case, especially when magistrates were being changed every other time.
Thank you very much for that. I also agree with you. Yes, it's from it. I think the case was filed in 2015. Until 2022, these people are yet to find justice. That's like 7 years. But one would argue that, well, it's not too long, that 10 years, but clearly if the issue here is a question of maybe unnecessary adjournments, or even where we're having the judicial officers being transferred and even they're not being a sort of clear way of handling these cases, that could be a good reason. So that could be a good issue that we could raise here as something which is key. Or even if you've forgotten everything, you can put it up there. Now remember, the question has 10 marks. So it means that for every issue that you raise, you need to explain it, and for you to get 2 marks for each issue that you've raised. So I don't know if we are satisfied with those answers given. And just before we move to the next bit, which will move a bit faster, I just want to know the one who had promised us, and even I gave them the burden to report to us what they.
Yes, I'm the one. Just looking for it. I'm the one. Ochieng, I'm looking for it. I saw it somewhere. We're doing this question, yeah. I'm just retrieving it, and we can just move, and then I'll tell you. I'll tell the class about it. Yeah.
Okay, thank you very much. It's okay. No worries. I think now we can move to the second question.
Sorry, my hand is raised. Sorry.
Oh, sorry. Yes, please proceed.
Yes, I have a quick one. Because we can see from the facts that the accused person, of course, there's that delay, as my colleague has just said, and then you can see the magistrates are being changed every other time. So I've read somewhere before that if a judicial officer has been moved from a case, then that accused person has a right to apply for retrial or new trial. Not necessarily new trial, but has a right to have their trial start de novo. So I don't know if there is another issue that faces the prosecution in this case.
Thank you very much for that point. And actually, before I move, I wanted to ask on that. And there are 2 things you've said about transfer of judicial officers and even the effect it has on this accused person. Now, most of the time I know, or I've seen this in practice, if this judicial officer really understands the file, or even maybe the case had not gone too far, the case won't have to start again. But if it's a very fat file, and maybe circumstances are that the witnesses are still alive and kicking, so, and even the accused person feels like, or even the prosecution feels like, we need to recall these people once again, so that we can ensure that even this judicial officer understands or even appreciates the circumstances. So now the court will order for, or rather will allow a de novo, like for the trial to start again. De novo means a new trial. So I think also that's very key, and also you can raise it, because if it means you're starting again, it means it will affect both the prosecutor and the accused person. So you can also raise it as an issue. Yeah, but please don't forget, I feel like there are so many glaring issues that you just spot on. Yeah, But these others that we are saying, maybe you could give them as backup, just in case you forget the ones that look so spot on. Yeah, because I also appreciate that people see things differently. So I also agree that that point is really an important point. Yeah, because again, it speaks so much to. Remember, you see from the facts, you're seeing witnesses being stood down, then you're seeing the judicial officer being transferred before the case is completed. What do we do with that? Do we order for a new trial, or does the new officer who comes now begins to do what? To order for the trial to begin again. So that's really, really important. And it's a point you can have. Just go look at transfer of cases, no, not transfer of cases, but issues about when judicial officer has been transferred. Maybe you could share with us the provision of the law. Our colleague who's just raised that point, or your colleagues also to go look further. Now we'll
I'm
move to,
having trouble finding it at the moment, but once I do, I will share.
okay, so we'll move to the second question on the 5 procedural safeguards that have been put in place to protect and support vulnerable witnesses and offenders. Yeah. So anyone? Yes, Chepchirchir.
Okay, good evening. So one of the ways that the law or the procedural safeguards that have been put in place is these vulnerable witnesses or offenders can testify, or their evidences can be taken through intermediaries, and that one we can find under Article 57 of the Constitution, which recognizes the use of intermediaries, which this one includes parents, relatives, we have psychologists, we have counselors, we have guardians, we have children officers and social workers.
I'm not sure if I can hear you. I don't know if the rest can hear you.
Sorry?
Sorry, I think you muted. So I just had your first point. Please proceed.
So you didn't hear me?
Saying I had your first point, but at one point I lost you. So I just had you give the point of intermediaries, you quoted the Constitution and also gave examples. But then at one point I saw like you muted yourself. So just proceed.
I'm not getting you well, but the point that I was giving is the use of when taking evidence of these vulnerable witnesses, we can use intermediaries, and this use of intermediaries is provided for under Article 57 of the Constitution. And these intermediaries include parents, relatives, psychologists, counselors, guardians. We have children officers or social workers. And it happens mostly when we have victims or witnesses such as children, minors. So if it is in sexual offenses cases, their evidence can be taken through their parents.
Okay, thank you for that. Any other procedural safeguard apart from intermediaries given by Chepchirchir? Anyone who wants to chip in? Guys, please give us these answers. We'll be able to correct.
Can I say one?
Please go ahead.
Use of we have an instance where the use of how do we say it? Okay. We have seen instances where evidence is taken in camera, that is, for example, in chambers, in order to exclude the proceedings from the public eye, for example, open court. Is there such an instance where witnesses are children, or where witnesses are children, or where they do not want to be identified with the public? I've seen such happen, and I think it's also provided for in the Witness Protection Act.
Okay.
Proceedings in camera or in chambers. That's it.
Okay, thank you very much. Yes, Bernard Ayeko.
Network,
Ben.
I don't know. Are we on
Yeah.
question 2, right?
Yes, we're on question 2.
Okay, I hope I'm not going to repeat what someone has said because I was away for a minute. So number 1, I identified the issue of support by intermediary. I also identified the question of interpreters. I also identified the use of pseudonyms as way of as part of the safeguards. I also identify access to an advocate as a safeguard. I also identified conducting voir dire examinations as a safeguard, and also where we have PWDs, I also identified the use of aids that can assist the PWDs. Thank you.
Thank you very much. Now, before we even proceed, sorry, I see Oyo Pius, your hand is up. Please say something before I can chip in.
Yes, this is a bit far-fetched, but sometimes an accused may be the court may fail to grant an accused bail for a reason for reasons of one of them being protection of witnesses, if the accused can interfere with the witnesses. I don't know whether that could also pass for this question as a safeguard. Just
That's an
perfect.
interesting. Don't say it's perfect. I think it's still within the criminal litigation realm. So, safeguards are in good place to protect and support vulnerable witnesses and offenders. So, I think I can look at it in 2 ways. Yeah. The vulnerable offender, sorry, the vulnerable witness, in the sense that if we let the accused person if we let them go, it means they will go and maybe interfere with the witnesses' life or something. Well, I will give it as the last resort. I don't know why. Yeah, I would give it as the last resort. Sorry, but not to say it's not an answer, because again, remember that's why in court we also have the minority and the majority decision. But I wouldn't say that I would
Yes.
give it the first safeguard. I would look for, remember also a trick in CLE, always begin with the powerful answer, or rather the answer that you know, even if somebody was closing their eyes marking, they'll still give you a mark. Yeah. But I wouldn't say it's not
Yeah.
impact. Yes, I've seen somebody else has
Yeah,
raised
that
their
is,
sorry, just say something, then you can like give it up to your colleague. Sorry.
no, I was just saying I'm guided.
Rispa, we
Thanks.
have 2 people. We have Anyona and Muhindi.
Mhm.
Yes, they have raised their hand. Muhindi has disappeared, but Anyona's hand is still up.
Anyona can then say something.
Yes, thank you. So I'm the one who raised the issue of the new trial, and I promised to find the law. And so I've found section 200, subsection 4 of the CPC, which says that if an accused person has been convicted by a magistrate who did not record the whole evidence, then that accused person may apply to the High Court to have the same set aside, and that the High Court orders for a new trial. So there's under 200 subsection 4. And then on the second part of the question, if I may, on protecting witnesses and accused persons who are vulnerable, we have the Witness Protection Act, Part 3, which talks about protecting witnesses from identification. And one of the ways that that can be done is through allowing them to use or assume a new identity for the purposes of that case. Thank you.
Thank you very much, Oscar. Just to comment, thank you that also you've gone further to really look up the rules of the law and also what you've given us, and I agree with you. Maybe, I don't know, Angelo, if the other colleague of ours is in, or maybe I can proceed and comment, then we move to part B. I see somebody's hand is up. I don't know whose hand is up. That's the problem of using phone. Anyway, so I'll just comment, then we can move a bit fast. So, first of all, the question is the procedural safeguards that have been put in place to protect and support vulnerable witnesses and offenders. I think here it will be very important just to quote, maybe show the examiner the legislation on, maybe if it's witnesses, if there's a law on that. So it will be good for you to begin with the Witness Protection Act. Even if you've not read it in its entirety, at least you're aware there is such a legislation that protects witnesses. And then number two, now you start giving what you guys have just given me, the issue of intermediaries. You can quote the Constitution, Article 57, the issue of also interpreters. Yeah, because again, you also need to understand, you as a witness, even you as an offender. You know, you've seen in court, if you've attended your judicial attachment, the court asks the accused person, will you use Swahili or English or even mother tongue? And even there's an interpreter to interpret maybe from mother tongue to either English or Swahili. Then number three, what you guys have also told me is about the issue of where people sometimes plead. You plead in camera, or even proceedings are taken in camera, so you're not able to, there's some sort of privacy here, especially for small children. And also there is the use of pseudonyms, or even where the court ensures that your name is not disclosed. This mostly happens where children cases are at stake, either it is defilement. Yeah, I hope you've seen that, or even you've heard of that. Then, of course, as a vulnerable offender, you need access to an advocate. You might be vulnerable. The term vulnerable, you can be vulnerable in many ways. Yeah, you could be vulnerable because you don't have an advocate. You could be vulnerable because even your life is at stake, you as an offender, or even you as a witness. So you need an advocate, especially as an offender. You need access to an advocate. You know, legal representation is a constitutional right. It's provided for under Article 50, if I'm not wrong, the Constitution. Also, what you guys have also raised is on the issue of conducting biodiet, especially also for children. So I think what we can pick again, remember CLE, always choose the strongest, always begin with the strongest. At least you know, if you're an offender, you need an advocate. If you're a witness and you need to, of course, you're testifying in court, you also need an intermediary, especially if you're a child. You also need interpreters, yeah. Also, sometimes how you testify. Will you be testifying from the dock, or will you be doing it in camera, yeah, or will you be doing it in open court? So you need to look at it in that way, brainstorm in that way. So we've said you need an intermediary, you need an interpreter, you need, of course, an advocate. You also need, of course, your name has to be protected, rather not to be disclosed. So there's the use of pseudonyms as a way of procedural safeguard. And also, lastly, having evidence taken in camera. And you can think of many more, but always remember it's a criminal procedure, or rather it's criminal trial. So issues of representation are very important. Issues of how even you testify. You need to know what safeguards have been put in place, and some of them we have mentioned. And I'm happy that all of you, or rather most of you, have contributed to that discussion, and we've been able to see what to do about it. So I'll move to question B. I think this is what I'll handle, then I'll leave it to my colleague. So question B, I want someone to read for us, then we can proceed. So anyone, please. And I hope you're understanding, or rather you are internalizing what we are saying. So anyone, please, question B. Any volunteer?
I can volunteer.
We have Lewinsky.
Yes, yes.
Yes. Oh, should I read? Or you're giving it to the other person?
Is it Lewinsky?
Yes.
Why
I can
do-
proceed.
Okay, please proceed. Then the guy, I had a guy's voice.
Yeah,
Can
true.
give us the answer.
No,
Yep.
I have given out to Lewinsky. Ladies first. Thank you.
Okay. Thank you.
Okay, thank you. So I proceed to read question B. Masha, a mother of 3, has been charged for the murder of her 3 children. During the trial, evidence adduced pointed to the fact that the murderer was occasioned by Masha's desire to avenge her husband's decision to marry Furaha as a second wife. After the close of the hearing, the court found that Masha had a case to answer. On the date set for the defense hearing, Masha was not availed in court. The report furnished by the prison authorities stated that Masha had been experiencing acute depression and had been incoherent in speech. She had, since the last court attendance, attempted to walk out of the prison facilities, purporting to be leaving for work, which affairs led to the authorities to believe she was not in proper mental condition. Explained to the court the procedure for handling Masha's trial. 5 marks.
Okay, thank you for that, Imuhiro. So maybe the guy who said ladies first can now give us his thoughts on that question.
Counsel, it was me, but I have spoken, and I don't want to monopolize the platform. Would you allow me to give Charity that space, another lady, again?
No worries.
Thank you.
That is in order. Thank you. Yes, Muindi Charity.
Okay, yeah. The procedure is provided for in section 162 of the Criminal Procedure Code. It's on lunacy proceedings, where the court does an inquiry as to the soundness of mind of this accused person. This is usually through an health expert. Yes, they do a mental assessment. So in this instance, if Martha is found to be of unsound mind, the court can now postpone further proceedings in the case because, as you have heard, the prosecution has closed this case, so they can't proceed to the defense hearing since the accused person has been declared of unsound mind. That is in that instance. And then after postponing, the court can either release Masha, sorry. The court can either release Masha on bail, and this is usually in instances where there is sufficient security that she will not injure herself or even other people around her. If sufficient security is not given, the court can proceed to make an order that Masha be held in safe custody, and this is usually in such a place and manner as the court may think fit, and in instances where that this person is going to be really taken care of and our needs are going to be met. And then the court minister in charge of prisons will now transmit the court record or a certified copy to the president, who gives a consideration, and the president gives recommendation. The act states that the president just merely gives an order, but Justice Majanja, in the case of SOM versus Republic, said that that is the instance of the executive interfering with the judicial independence, and therefore whatever the president gives nowadays, it's just mere recommendation and not what is supposed to happen. And then the court now will come back and give directions considering the recommendations, but the recommendations are not going to bind the court in that instance. So for me, that is the procedure of handling Marsha's trial. I didn't go the other way because from the facts, it discloses that there is a high probability that she'll be of unsound mind. Yes, thank you.
Yeah, thank you very much, Charity, for that. I don't know if there's another hand up, but I'll just comment and just say, yes, Munyo Nuru, before I comment.
Can I say something before you comment?
Please proceed.
Now, if you look at, yes, I agree with the previous speaker with regards to inquiry by court as to soundness of mind. But there's also a situation where there's someone, the accused might be of unsound mind, but still capable of making a defense, and is provided for under section 163 of the CPC. And it says, for example, that if a person detained in a mental hospital or other place of custody under section 162 or section 280 is found by the medical officer in charge of the mental hospital or place to be capable of making his defense, the medical officer shall forthwith forward a certificate to that effect to the Director of Public to the DPP. And then the DPP is required to inform the court which recorded the finding concerning the person's unsoundness that it is the intention of the Republic that proceedings against that person continue or otherwise. So I just thought it's important to bring that to the attention of the class, that there are instances where the person might be of an unsound mind, but still capable of making that defense. And it's upon the medical officer to issue a certificate to the Director of Public Prosecution. Once that is done, then the DPP is supposed to inform the court of his intention to continue with the proceedings. Then if you read subsection 3, it says that the court shall thereupon order the removal of the person from the place. We assume in such instance it's a mental illness hospital or something, where he's detained, and shall cause him to be brought in custody before it, and shall deal with him in a manner provided for under section 164. Otherwise, the court shall issue an order that the person be discharged in respect of the proceedings. Yeah, it's just essentially what I've said, that then once the DPP makes such a request to the court, then the person shall be brought to court from wherever place he is detained for the court to proceed as provided for under section 164. Thank you.
Thank you very much for that. Thank you for the reactions from both Hilary and Charity. And I just want to tell us, if you look at question 1, even just the whole of it, and even maybe as even you continue to read, this is something I really helped me when I was preparing for my bar exams. When you look at your course outline, I know you're aware that there are topics which will never miss, like bail, bond, child process, and what else is tested, yeah? But if you look at this question B, it was testing on lunacy proceedings, which I think it's always given like a small bit on the course outline. What I'm just trying to bring to our attention is, please don't despise your course outline. Know at least every topic, if not all of the topics in that course outline, because the CLE, it tests everything. I don't know if you will notice something peculiar about the 2023 March exams, not only for criminal procedure, but especially for other units like conveyancing. Sorry, I'm just detoured, but just to bring it to our attention that please know your course outline. Yeah, know all the topics from the course outline. It will really help you survive and really know, at least have an idea of every topic on that course outline. Don't despise the last topics, because this lunacy proceeding is not even among the first 5 topics, no. And even some of the lectures at KSL never teach it. So woe unto you, yeah? Woe unto you if you don't know what your course outline, what a topic in your course outline says, yeah? I'm not saying that you need to cram and know everything, but it's good to at least know something about a topic, especially these last topics which are hardly taught. Or rather, time has always lapsed and maybe they're not taught. Yeah. So at least have an idea. Just know something about them. And I'm happy that you've brought legal provisions on this question B. And remember, the question was explained to the court the procedure. So other than raising or rather giving the legal provision to section 162 and also trying to maybe distinguish it from section 163 and even 164, what they say, it's good for you to know the procedure. I don't want to add anything on what Charity and both Hillary have said. So, but I'll just ask us to go to those legal provisions and maybe Charity could send a screenshot of that, what she was reading on the WhatsApp for people anyone who wants to make further notes or even further reference in future. But I'm just trying to show you that question B. Yes, it's 5 marks. But it's a topic which I don't think even we were taught. I think we were taught when we're talking about insanity. Yeah. When you're placed on your defense and you can't defend yourself because you're not mentally capable. You see, it was just said in passing with no procedure or rather no legal provision, just the common thing that you can't testify when you're not mentally okay. Yeah, because you don't have capacity even to reason and to adequately address the issue at hand. So please know your course outline. And just to say that I don't want to add anything that has been said by your colleagues, Hillary and Charity. Thank you very much. I think at this juncture, I'll leave it to Angela to take up question 2 and 3, or rather question 2, sorry. Then I'll come back and pick it up question 3. I don't want to speak so much and make it a bit boring. So you also need to hear a masculine voice and not just a feminine voice. So Angelo, please take over. Thank you.
Thank you so much, Honorable Rispa. Ladies and gentlemen, let us clap for her. She has really done a great job. Pigeni makofi tafadhali. She's an aspiring professor and maybe she will be teaching some of us at the Kenya School of Law. Tumpige makofi. She was really good. Eh? So on this juncture, I will allow my learned friend. This is one of our best questions. Even the other one is also very okay. So, and one thing I would add, you see, even if the questions will not be repeated, maybe from what we say, please know your course outline. You will not meet private prosecution. Is it extradition? Is it habeas corpus? One of those three. There must be this specialized proceeding. There must be one question. And you realize most of the time you will not be taught. Okay, so then that becomes an issue, and that is why we really encourage you guys, just try to go to those final last topic, the same way I told you about execution, judgment when we were discussing civil litigation last week. So I will call upon my learned friend Esbon Oko to take you through question number 2. Then we will proceed in that order. Then our host of the day, Rispa, will come back again. So Esbon, I have Njeri hand is up. Maybe you can take over from here, sir. Thank you. You can clap for me as well.
Brother Angelo, you can see very many people clapping for you. It means a lot. Hello. All right, let me also clap for you. Anyway, so guys, I really don't know how you've been proceeding with the previous questions. Maybe you can get guidance from Honorable Angelo. Have they gone through the questions so that we just heading directly to the question, or you reading particular question? Kindly just direct.
Yes, sir. We are reading particular question. Eh? So like now we are in question 2. So someone will read for us question 2. Then our colleagues will proceed to give the answers. They will raise their hand. We will be picking from one by one. Thereafter, we'll give our conclusion on that particular question. And since time is really long, so we'll try to move with speed, because now is 10 marks. RISPA has completed the one that would take a lot of time. So this one now, even 30 minutes or so would be enough. Under 30 minutes would be enough per question. So Njeri, you want to read the question? Your hand is up.
Yes.
Okay, thank you. Esbon, take it away.
Okay, I'll allow Njeri to proceed with reading the question.
Okay. Doige Sugunyo was convicted by the Chief Magistrate Court at Makadara for the offense of defilement contrary to Section 8(4) of the Sexual Offences Act. Upon conviction, the resident magistrate, Honorable John Said, sentenced Mr. Sungunyo to life imprisonment, stating that it was a necessary sentence due to the rising cases of defilement within the court's jurisdiction. Part of the trial court's judgment dated 11th November 2022 read as follows. Convinced without doubt that the complainant in this matter was below the age of 18. Years as submitted by the prosecution. Even though an original birth certificate was not produced in this case, I'm convinced that an age assessment was not necessary, as the copy of the birth certificate produced indicated that the complainant was aged 17 at the time of the offense. Furthermore, the complainant had not completed her secondary school education, having dropped out in Form 3 that year. This evidence is therefore conclusive enough to reach a determination that age as an essential element of this offense was satisfied. The accused, in his defense, argued that he was led to believe that the complainant was not a minor, and in this regard, he has relied on Section 8, subsection 5, and subsection 6 of the Sexual Offences Act to argue that the complainant held herself out as an adult, which led him to reasonably believe that she was one. The accused further argued in his defense that he had stayed with the complainant as husband and wife for a period of 1 year with the knowledge of her parents, that this complaint arose from his failure to raise 50,000 Kenya shillings, which had been demanded by the complainant's father. I find this defense unsuitable, as the accused ought to have known that the complainant was a minor, having been in the same secondary school. Doige Sungunyo has now approached you to pursue an appeal on his behalf. Draft the necessary appeal, 7 marks.
Okay, thank you so much for reading the question. So I believe we all have rather now conversant with the set of facts, which is very important for us to read the question. So just read the whole questions, the 2 questions, so that we get to know the scope of the questioning. It's important to just read through the question before we start answering the first one.
Okay, B, citing case law and relevant legal provisions, advise your client on the possibility of being granted bail pending appeal, 3 marks.
Okay, thank you. So now the first part of the question, which is A, you are required to draft the necessary appeal. So maybe before we have a discussion from our side, I'll request the plenary to weigh in their views on how they have approached this question or what they think the question is testing on. Any volunteer? Yes, I can see Ochieng Hillary. Kindly just proceed.
Part A, that is draft the necessary appeal. The question is trying to, actually what it's testing actually is whether we know which court to go to when we need to appeal from the Chief Magistrate's Court, a decision of the Chief Magistrate's Court, and what documents we need to draft in lodging such an appeal. So yeah, that's what it tries to, that's how I understand it actually.
Okay, thank you, Hillary. Hillary has mentioned that it's important to get to understand, first of all, which court are we lodging our appeal and which are necessary documents. There's another hand. I don't know, I can't see on my side. Angelo, can you see the other hand on your side?
Yes,
My
my
hand said can.
lord, we have Donna, that is Odor, and Dishero Ann. Jerry, is that
Okay.
a new hand? Or it is that one that you read the question?
It's a new hand.
Okay.
Okay. Let Donna proceed and then maybe Jerry.
Okay.
Okay, so my contribution on this, other than the appeal, there's also the issue of time, since the judgment was issued on 11th November 2022. And now we've been told Loenge has now approached you. So we're told you use that, like, judgment was issued then and then you write it. You're supposed to appeal like at this time as of to date. So you'll also seek extension of time to appeal.
Okay. I believe that was Donna. Pardon? Yes. Yes.
Maybe you can allow me to respond on this just for a second.
Okay. Okay.
Yeah, you see, Donna, the question is saying draft the necessary appeal. So what really happened is you just do that, okay? You don't infer anything, you don't draft anything else, okay? That is why I said last time, you go focus on the questions that have been asked. You can really know that maybe the time of appeal has lapsed. But what the question is telling you is that draft the necessary appeal. So you go directly and draft that said appeal. Okay, thank you.
Okay, thank you, Angelo, and for the clarification. Just a highlight on that before we let in the next volunteer. You always have to be very careful, especially look at this, it's 7 marks, remember, and the document you're going to draft really, it really takes much time for you to draft. So you need to be very careful so that you don't belabor in a document that is right, yes, but it may not earn you mark. So this one is just directly draft the necessary appeal. Okay, we'll see maybe how to get challenged about the same. But for now, I think let's just focus on the appeal as Angela stated. Any other person? I don't know. I can't see a person on. I can only see hands, but I can't see the names on the other side. Kindly, Angela, just lead me through the session on this part. Is it Mukuna Njeri? Kindly just proceed, unmute and proceed.
Okay, so this was my attempt. So I had begun up there with drafting now a petition of appeal. So up there I began with in the Republic of Kenya, the High Court of Kenya in Nairobi, criminal appeal number dash of 2022. The appellant is Doige Sungunyo versus Republic as the respondent. Then the title of the document is petition of appeal that is brought under section 350 of the Criminal Procedure Code. Then I proceeded to say that after that part I say, being an appeal against the conviction and sentence of Honorable John Said, delivered in the criminal case number 37 of 2022. The case was Republic versus Doige Sugunyo, that was delivered, which judgment was delivered on 11th November 2022. Then the first paragraph is that the appellant, Doige Sugunyo, hereby appeals against the conviction and sentence of the Chief Magistrate Court at Makadara in criminal case number 37 of 2022 in the following grounds. So I am not very conversant with how we bring out our grounds, but now from the question, from the way the question is stated and the issues that we will be appealing about is one on the factors that the Chief Magistrate used to convict the accused. That is the issue of age, where the Chief Magistrate then went ahead to infer that this person was a minor without getting much evidence into that. and also not considering the averment by the defense case that they were living together as husband and wife, and that the defendant, or no, the accused believed that this person was of age. Another reason is the illegal sentence of life imprisonment, which is contrary to Section 8, subsection 4 of the Sexual Offences Act. And another ground I saw is that the magistrate refused to take into the consideration the defense of the accused, that he reasonably believed that the person they were living with was not a minor. But now how to phrase those as grounds in the appeal, I will hear from this class. Then the ending will be the reasons wherefore the appellant prays that the conviction and sentence be set aside. Then there is dated at Nairobi this day of this year. Then it's signed by the advocates for the appellant, and then it is going to be, then it's drawn by this advocate for the appellant, and then it will be served on the office of the DPP.
Wow. She's actually literally drawn the whole appeal. Do you have it? Like, had you drawn it before? Because I feel like you literally have actually drawn it.
Yeah, yes, I have. I had drafted it as I was going through the question.
That is so good. So maybe before we have a finality on the same, let me just give a chance to Charity. I think you've lowered your hand, but I'm sure you had something to mention about the question. Just share with us kindly.
I hope you can hear me. What I wanted to say is that we're still in the preliminary on the factors that we need to take into account as we begin drafting. So one issue identified, because this was a magistrate court, which is a subordinate court, when you're appealing the first appeal, as per Section 347 of the Criminal Procedure Code, you should appeal on both instances of facts and law, and some instances or general grounds for appealing criminal cases. It's usually in instances where relevant factors were not considered. For me, I thought the fact that the victim's father wanted some money which were not given to him should have been considered by the judge in giving that particular sentence. Also, in instances where the sentence is excessive, I tend to think that also the sentence imposed was a bit too much. I am not sure whether now the sentence imposed is against any legal principle, but I have heard the previous speaker who spoke before me say it's a section of the Sexual Offences Act. Maybe she can just put it on the chat. I really didn't hear it well. Yes, and in the instances where there is irrelevant matters which have also been considered. Yeah.
Okay, thank you so much, Charity. Do you have any other person who want to weigh in? Any other person who's made maybe an observation as the previous person have been presenting? Okay, then. Oh, all right. You can see Donna. Donna, just proceed.
Mine is a question. Do we refer to the appeal from the subordinate court to the High Court as petition for appeal? What is the, okay, is that the correct term?
Okay, there is that question. How do you refer if you're seeking to appeal a decision of the magistrate to the High Court? Remember, it's a petition. It's just a petition. Anyway, can you now hear maybe from the discussants? Rispa, then Angelo, then I'll have our way on the same. Then we can.
Excuse me, Oko.
Someone was speaking. I let you to proceed.
I'm responding to what the previous speaker has asked. Section 8, subsection 4 of the Sexual Offences Act provides that a person who commits an offence of defilement with a child between the age of 16 and 18 years is liable upon conviction to imprisonment for a term of not less than 15 years. So that is what I was inferring to. But now we find that this person was sentenced to life imprisonment. So I thought that is contrary to the provisions herein.
Okay, fair enough. Can we have a contribution from Rispa, then Angelo, then we'll have to conclude the question on how to draft. And the most important thing I expect maybe Rispa and Angelo to address, we've been asked about drafting an appeal. So if you're asked about drafting an appeal, whatever you're being tested is, you're being tested to show the your understanding of the format of an appeal, how the document will have to appear. For example, not the form, how the document will have to appear, but rather the format of the structure of the document, the structure of that appeal, like starting from which court are you going to appeal, how shall the parties appeal, under what law are you going to appeal on, then what are the grounds, what shall be the grounds of your appeal, and really everything about that document. And also I think I don't know what was her name, but she really mentioned well, there shall be marking points at various points, including the grounds. Each ground may have a mark until that last point of the service upon the DPP. So it's just like a whole structure you're being asked. Then the next thing that you maybe shall have to grapple with is what are the grounds you'll be basing on to bring your appeal. So there is really not much about this. I'll just want to maybe hear from Rispa what she'll maybe have come up with in terms of grounds. Then Angelo can tell us the best structure that he would have adopted or readopted for the purpose of this question.
Okay, thank you, Stefan. Actually, I don't have much to say because I think you've read my mind, yeah. And just to echo what you said, it's just basically the format and especially even which court you're appealing to. And I love how the first speaker, or the first person who contributed as the first person said, or even whatever she gave is I think that is what is important. Again, there is of course marks for grounds. I had not thought of the grounds because not because it's hard, but because they can easily be found in the facts. So just get the grounds clearly, and also of course, we always say when you're drafting, lazima ufunge. You have to close your pleadings. You can't leave them hanging. Meaning you have to serve them. Yeah, of course, you serve them to the ODPP. So I don't have much to say, just to echo what you've said, Hesbon. I'm sorry for not meeting that standard that you had set for me. Yeah.
It's okay. I think much was said by the plenary, and especially I'm really forgetting. I don't know if it was Jerry that already read the whole appeal. Unfortunately, I did not have a chance to draft it, but basically whatever she did is exactly almost the same as what I'll do, because for the purpose of exam, even in any unit, for example, if you're asked to draft a contract, any kind of a pleading or even application, we're just interested in knowing, do you know the format? Do you know the grounds you're seeking? The prayers you're seeking, and what grounds are you relying upon? And what are some of the standard things, for example, how the parties appear? the service, how you affect service and whatnot. So for this one, it was just asking you about that. So you'll realize that even for you to score the 7 marks, you may not necessarily have to know all the exact sections of law that you're relying upon, as long as you at least know 1 or 2 and identify any of the error that you feel the trial court made, so that you actually come up, you actually frame a ground from that kind of your discovery on the decision, the error instead. So I'll let Angelo have a voice on this. Angelo. Well, it appears he's engaged somewhere. So what I'll request is I can request now that I've not actually drafted it, I really don't know the best approach to do this, but that document which was sent, or rather not which was sent, but which was being read, I don't know if you'll be in a position to share with us in the group, and then we can have a look at it, and maybe we can have our contribution to it. In case of anything, we can just make comments on it. But I agree the structure was well, the grounds were well framed. So on this question, just pardon me, it needed me to have drafted earlier enough. I didn't have a chance to have it drafted. So maybe we will just go to part B of the question, which was already read. And it says, citing case law and relevant legal provisions, advise your client on the probability of being granted bail pending appeal. So this question is actually, oh, I can see a hand. Just proceed.
Hello, good evening. Am I audible?
Yeah, you're audible.
Okay, I'm Penston. I wish to take us through the bail pending appeal, and it is provided for under Section 356, one of the CPC, which allows the High Court or the subordinate court which convicted the accused person to grant a bail pending appeal or to stay the execution of the sentence. And as to the considerations, they kind of differ with other considerations for other types of bail, because the one which is mainly considered is whether there is an overwhelming chances of the appeal succeeding. And this was stated in the case of Abdi versus Republic. And it was further stated in the case of Opondo versus Republic. Now, apart from that, the issue of overwhelming chances of the appeal succeeding, there are other secondary considerations which were stated in the case of Birundu versus Republic, and some of them include the medical condition of the applicant, the nature of the offense, the sentence imposed, and the likely delay in preparation of the appeal record and hearing of the same. Now, Now advise your client on the possibility of being granted bail pending appeal. To bring now the issues home, because we've seen that from our view, the trial judge in rendering his judgment left out key issues which ought to be considered to render just verdict. We can say that our appeal has overwhelming chances of success if the facts are really considered in a better way. And therefore, we can advise our client that based on that one ground, which is majorly what is considered for bail pending appeal, then he might have a chance of getting the bail. Thank you.
Thank you so much. You said your name was Pestan. Okay, I'm sorry. I didn't really get your name well. But you really, pardon?
Penston.
Penston. Wow, I'm really impressed. Really tells me so much about your preparation. The question has really been well answered. So in approaching such kind of a question where you've been requested to rely your answer on relevant case law and legal provisions to advise, be very careful not just to rely on the case law and the statutes that you know to the extent that now you forget about the advisory part. It's important to just have, anytime you hear of an advisory or any kind of question, you can either pick to use the IRAC or actually the IRAC will do well for these, or even FIRAC. But now for FIRAC, at times you may find a marker is not interested in you regurgitating the facts, so that the best thing will be to just have the issue being whether the client shall be granted bail pending appeal. So that is the issue in the IRAC. Then now you go to the rules. So you say that in Kenya, the rules that govern, or rather the governing law of bail pending appeal is this section of law. Then after that, various court, or it's now judicially settled that these and these shall be considered as it was settled in the following cases. Then now you bring in various cases as have been discussed. Then now after that, you now try to come up with your facts. What facts do you have in respect to your client? Which situation or circumstance do you think your client is in? And how can you apply your circumstance to the circumstances which the cases you have relied upon had? Then after that, you now make the advice. Sometimes you may still find you are getting full marks, not you're getting full marks, not necessarily having an accurate answer, but the way you reason, as long as you're sound and you make sense, I think you shall be entitled to the whole marks. So remember, the marks is 3, so you don't have to waste a lot of time on it, but it's important to bring out all the things, all the law, all the sections of law you remember, all the case law you remember, then briefly the facts you have, and then the advice to them, and even the possible outcome when the same is presented to the court. So I don't know if there is any other contribution to this, but I think it's really been well answered. I know we may have different case law in respect to this, especially the aspect of bail pending appeal. At times you may also be asked about bail pending second appeal. What factor? What is the de jure factor or de facto factor that shall be considered? For example, the aspect of the possibility or the success of an appeal. If there is a high chance of success on an appeal, that is one of the factors that the court shall consider in granting. So various courts have stated the same, or actually have relied on that factor to grant the bail pending appeal. So that is really how you'd argue about and to get the 3 marks. So I don't know if there is a question in respect to this, but where I sit, the question is well answered. Any question? Okay, I take the 10 seconds silence to mean everything is okay. So just to reiterate that when asked about advise a client, and these are the kind of questions that you of course face, advise a client using relevant whatever, please adopt the IRAC as the best mode of answering that kind of a question. Thank you. Over to you, Rispa.
Thank you very much, Shazbon. I hope what Husband has just told us is making, so you've understood, and of course is making out of sense. So we'll move to question 3 very fast. So I also request someone to read for us question 3 kindly. Kindly.
I can read it.
Please do.
Question 3. Mzuri intended to purchase land to construct a house for her mother. Her colleagues at work referred her to Ngamwaya, the land broker. Ngamwaya led her to Tapeli Bonoko, who showed her a half an acre plot of land at Maji Mazuri area. She was then shown copies of title deed and a search for land reference number K/Maji Mazuri VJ/2. She was referred to the land registry to meet one buyer for faster processing. Buyer confirmed to her that the land belonged to Tapeli and issued her with a search certificate. Zuri and Tapeli executed a sale agreement before an advocate who is a friend to Ngamwaya. Buyer Ngamwaya and Tapeli's wife, Giza, were all witnesses to the sale agreement. Zuri paid 2 million Kenya shillings, being 75% of the purchase price as deposit, and the balance was to be paid by the purchaser once she receives all completion documents to help her effect the transfer. Upon execution of the agreement, she took possession and moved to fence off the plot. She was stopped by Mzee Moja, who claimed to be the owner of the plot for over 3 decades. He showed her the title documents in his possession. She then tried to call Tapeli, but the line went dead. She could not reach Ngamwaya and buyer either. She went to the lands registry to follow up and found out that no one by the name buyer or his description is an employee of that office. She reported the matter to the police upon discovering that the copies of title deed and such certificate she was given were all forgeries. On learning this, her husband, who had financed the transaction by taking a loan from a bank, was distraught. This strained their relationship, leading to separation. He lost his job from the impact of the anguish, and as a result, their children were transferred to public schools in the village. After a manhunt, the police arrested Buyer. He led them to Ngamwaya, Tapeli, and Giza. On investigation, it's been discovered that the money paid on the transactions were used for different purposes. Tapeli had bought a car, Ngamwaya was on holiday in Ukunda, while Giza and Buyer had received 100,000 Kenya shillings and 20,000 Kenya shillings respectively. Explain the action to be taken against Buyer, Ngamwaya, Tapeli, and Giza. And B, given the circumstances of Mzuri, explain the role of victim impact assessment. Thank you.
Yeah, I hope you can hear me. Thank you very much for that. I think now we'll move very fast. The answers. So anyone who wants to give it a shot for question 3A? And just to put your attention, please just note that question 1 was on trial process. I think also 1B is on lunacy proceedings, and question 2 on appeals, the topic on appeals, actually drafting. Then question 3 is on bail, but specifically bail pending appeal. Those are like, I think, 4 or 3 topics. So now question 3, I want us to discuss what it's all about, and we can see what to do. So anyone, please, I know you're a bit tired, yeah? I know you're a bit tired, but we can do this. Please, let's do this. It's not a must for your answer to be correct. Correct in the sense that we are all learning. Yeah. So please just give what you have, then you'll be able to see. Anyone? Oh, yes, I think I've seen a hand somewhere. Yes, Jerry. Yes, Mukula and Jerry.
Sorry, forgive me, the noise here. I think it is, we are being tested on the offenses that have occurred in this scenario and what each of the people mentioned will be charged with.
Okay, thank you. Also remember, these people have been arrested from your criminal procedure. Remember, it's a procedure. So after arrest, you are arraigned in court. And of course, some charges are preferred against you. Yeah, so proceeding from that train of thought, I want also to hear from Charity. Thank you so much, Njeri.
Maybe you have kind of preempted what I wanted to say, but they'll be presented before court within 24 hours because they were arrested. The court can either, yes, and also the possibility of bail can be, they can be granted or not according to the circumstances of the case, whether they can still interfere with the investigation or they can to appear before court. So after, and also before, prior to presentation before court within those 24 hours as per section 49, no, article 49, sorry, of the Constitution, charges will have to be drawn. This one, maybe you will guide me, but I think they can be charged with obtaining money through false pretenses. Yes. And then, according to what they answer to the charges, the trial can begin. And yeah, now I'm not sure where you should stop against the action which are taken through them. If you're going to go through the whole process of the trial, or you're just going to stop upon presentation to court for plea taking. And yeah, whether you're going to proceed on setting the matter for hearing. Yes.
Thank you for that. Anyone else? Yes, Onyango.
In answering the question, I think the proper action to be taken is them being charged. So they are supposed to be charged. And in answering the question, I'm inclined to believe that you are only supposed to limit your answer on the aspect of charging, because that's what happens after investigation has been done. Because if you then proceed and talk about the trial process in its entirety, you'll be going on a different tangent and the examiner won't even mark that part, because the immediate action in this particular question is just the charging. So in answering the question, I think we should just talk about the process of charging, which will be, they'll be arraigned in court and they shall be charged. In the instance that they are not being charged, they are supposed to be given reasons as to why they are not being charged. So we should just talk about the charging of the three suspects. Yes.
Thank you very much, and I agree with you. Because again, remember we're just coming, sorry, the question says the last bit is they were arrested, yeah? And of course, investigation have been completed. So now how do you get the 4 marks? You need to ensure that, of course, your answer is of course, they'll be charged. But now ensure that for Baya, there's a charge that would be preferred against him. For Ngamwaya, there'll be a charge preferred against him. For Tapeli as well as Giza, yeah? And from your what? From your, what do we call this? From your, I'm forgetting the name. From the facts, you can clearly see what really happened. So every person who's been listed here, you have to prefer a charge against them. Whether you can decide to charge them together. I think it's called the joinder of persons. Depends if the facts are the same or whether it's in the same transaction, or joinder of counts, but this is mostly of joinder of persons. So you get those 4 marks by either listing every charge as per person or even having them as joinder of persons. So you'll have the charge, the name of the charge, and also the particulars, yeah, for you to get the 4 marks. Just not saying you'll charge them. What entails a charge? A charge has the statement of the offense, not the name of the charge, sorry. Statement of the offense as well as particulars of the offense. So once you're able to do that, you'll be able to get the 4 marks. Who can point to us one of the, what kind of charge they can prefer against Baya, or even Ngamwaya, or even Tapeli, or even Giza, anyone? Then we see what we are meant to do there, rather than just saying prefer charge and particulars. Anyone? I think Hesbon, your hand is up. I don't know if you want to help first, but maybe we could give you a chance to talk before they can respond to that.
All right, thank you, Rispa. I actually just wanted to give light on how to proceed on this question. I think Wanyango has made a good clarification on the same. It is possible, and it's true that when answering this question, you can really undertake to have the whole trial exercise, so that they're arrested, they're into court, the entire hearing, the conviction, anything, the plea bargain, and everything. But in answering this question, you need to be directed by marks, and you just need to be directed by relevance, so that just look at what is the immediate action, the immediate step that will happen immediately on the arrest, if they have been arrested. So the next thing is the next administrative action, and which is them being arraigned in court. So that can actually be the point, that once they're arrested, the police will have to ensure that charges are drawn against these persons. So 4 marks can be structured in terms of 1 mark for every person, and then the first mark for the introduction, to just say they'll be arraigned in court, then charged differently, or at times jointly, and then the last one, you have, let's say, for example, a charge where you'll have all of them being charged. So now you pin down and go to Baya. What did Baya do in respect to this wrong, or this wrong which is with us? Then what did is it Ngamwaya or Nyamwaya? Ngamwaya do, Tapeli and Giza. So I think the scope of the question, or rather the scope of your answer, should just to be to the extent of their charges, just being tested about what charges can you bring against, or can you level against these particular individuals. There's a charge that shall be, I don't know if there is a single charge for individuals, but they are actually joint charges. For example, you can charge them jointly. For example, conspiracy to defraud, which can be charged against I think Baya. Is it Baya or Ngamwaya? Well, we can refer to the facts, but there was an aspect of conspiracy where they conspire to defraud the purchaser. So the two can be charged jointly. Then you find another person. What did they do? For example, an aspect of aiding, abetting, and all those sorts of the charges. So I'll appreciate if we can maybe have our answers run or revolve around that. Thank you.
Thank you very much, Hesbon, and I agree with you on that. Anyone else who wants to give their contribution on question 3A before we move to 3B? Anyone? Okay, then we'll move to question 3B. Anyone who wants to give a shot or give a try on question 3B, what is expected of us? I think somebody's hand is up. I can't see well. So please just, if your hand is up, just talk. Sorry, just talk.
All right,
I can't
thank you. If I may, the question on victim impact statement. So my starting point would be section 12 of the Victim Protection Act, which says that victims have a right to prepare that statement, which shows the harm that they have suffered, be it physically, economically, or socially, or psychologically. And then if they have a problem of preparing that statement, they can contact the services of an agency who will then help them come up with that statement. Then I go to the CPC under section 329 capital A to F, to capital F of that section, talks about victim impact statement. And under part A, it defines who a victim is. So there are two types of victims. There's the primary victim or the family victim. So because the question is specific on the, is it the benefits or what, the role of the statements. So because under section 329C of the CPC, it says that the statement is received by the court after conviction, but before sentencing an offender, then I think the role of the statement is to help the court determine what sentence is appropriate in the circumstances, which sentence will serve the ends of justice. That's what I have to say on that question.
Thank you very much. And just to say that also this issue of victim impact statement is also on the course outline, but I think it's either it's on the law, on the trial, I can't really recall, but it's also a subtopic on the course outline. You can't underscore the fact that knowing your course outline is very, very, very important. So I'll begin by also highlighting the various sections of the law that speak to victim impact statement. We have the section, I can't really recall, but I know the Criminal Procedure Code. If we just do a control find, either if it's on section 327, I can't really recall the section, but just it's good for you to know what provision of the law speaks to victim impact statement. Yeah. And also, I think there's a victim impact victim impact assessment. There's also an act to that effect, if I'm not wrong. Please look out for those. They really help you also get more that couldn't be said. Not just knowing the role, but even what's the effect of victim impact assessment when it comes to even sentencing? Are courts, especially criminal courts, bound to maybe look at them before they issue a judgment or even arrive at a judgment? So also look at that and even look at case law, yeah, to help you in that. I'm sorry, I don't have something to give you, but I think the Criminal Procedure Code will help you, and also the Victim Impact Assessment Act. I think there's an act to that effect. Yeah, I think there's an act to that effect. Otherwise, that's how question 3 was to be addressed. I think in ending, or even if you have some more time, you can also look at question 4. Hesbon, over to you again. Maybe we could do it as the last question. I don't know if you guys still have energy. Yes?
So, Rifa,
Yeah?
I only wanted to weigh in on part B, and then maybe I let you proceed. I may not be able to proceed with question 4. I had something on question 4, on question 3B.
Okay.
So now, guys, when you asked about the victims protection, or rather victims impact assessment, there are two limbs of this question, or rather you can actually have a question in come in two ways with respect to victims. So that the first question can be, you can be asked to discuss the role of victims in criminal justice system, so that the casing point pins you to the Joseph Lendrix Waswa. You're supposed to know to what extent can a victim participate in a trial. And basically, we understand the justice system in Kenya is that we have the prosecution who actually are responsible for your case as a victim. But then with that case, I think that is where the aspect of watching brief and the advocates watching brief are now given a chance to like participate to some extent. So the first question now can be, what is the role of victims in criminal justice system? So when you asked about the role of victim, remember, what do you think the advocates watching brief can do in criminal justice system? They don't just take a role of the inactive role, but they can be active, especially if I'm a prosecutor and like I submit on some points and I miss out on one. Such kind of an advocate can bring out that kind of issues. The another one now is this one, where the victim impact assessment, for example, victim impact assessment is important way from the starting of the charges, the plea bargain, the sentencing, I mean, as in, I don't know. Yeah, so all those stages in criminal justice system, starting from when can we undertake, for example, a plea bargain? Yes.
Okay, thank you very much. I don't know if people in the room have energy for us to continue, or if people are tired. Yeah. I don't know. I want some feedback.
Usually we finish a paper. That is
Okay.
always our target. Yes. So we have 1 hour to go. We are
Okay.
still energetic.
Good to hear. So thank you very much, Hesbon, for the feedback. So I think we'll go to question 4. Hesbon, do you want us to help with question 4? Or maybe you'll help with question 5. Hesbon? I don't know if he's here. Yeah. Okay, maybe I'll take question 4. Then he'll take question 5. So question 4, anyone who wants to read for us? Maybe Bernard can read for us. If you don't mind, Bernard.
Thank you. I can do it. I can do it. I hope you can hear me. We want to complete the journey. We want to complete the journey. So question 4, Johnny Jamo is a prominent opposition figure in the Republic of Dagestan, a Commonwealth country where he unsuccessfully vied for presidency in the last election 5 years ago. In the build-up to the upcoming general election, key members of his Freedom Party have been subjected to arrests on allegation of planning to overthrow the government of incumbent President Tan Tun, who has sought re-election. Despite these arrests, pollsters have placed Johnny Janu ahead by a huge margin against President Tanu. 1 week ago, a warrant of arrest was issued against Johnny Janu on allegations of committing the crime of gross unpatriotism. Contrary to Section 5 of the Patriotic Act, a legislation which has been criticized by human rights bodies for being a tool for targeting political dissenters. Many of the political dissidents who have been tried under this law have been detained for years without trial. Dagestan has also been cited by the United Nations Committee Against Torture for its use of unconventional methods of interviewing suspects, which include being placed in the same room with menacing dogs while in police detention. in order to attract false confessions. Fearing for his life, Jaani Jaanu left the Republic of Dagestan for Nairobi, where he's currently being hosted by political dissidents from his country. President Tun's government has made a formal request for the extradition of Jaani Jaanu to face justice. Citing case law, advised the Director of Public Prosecutions on the chances of success of the request were it to be taken to court for determination. 10 marks.
Thank you very much for that. Anyone who wants to give us some contribution on what they think that question was testing and even how they will approach it? Anyone? Anyone wants to try? Yes, Charity, thank you.
Maybe what I would start by is looking at the instances where extradition is possible. Just from the reading of the facts of this case, it's not, you should not extradite anyone who is facing political trials. And in this case, you can see that this person is facing a lot of political, the case is majorly political. So on that instance, I would say that if this matter was brought before the court, that if the DPP presented an application before for extradition proceedings, the court would not allow. So the chances of success would not really be high because of the political nature of the offense that this particular person faces in when is extradited back to his country.
Thank you very much. So it's a question of extradition. Mwendi, your hand is still up. I don't know if you want to say something else, or should I comment?
You can comment. Sorry.
No worries. So yeah, it's a topic on extradition. Again, it's among the last topics on the course outline. Yeah. So you need to look at the legal framework that speaks to extradition. I can't really recall, but I know that there's some sort of that, not really two legal frameworks, but there's a framework on extradition. There's also ought to be something called reciprocity, like two countries ought to have been in some sort of agreement, yeah, between each other. But again, looking at the facts, remember this is a Commonwealth country. So again, that also speaks to something around reciprocity. So I think they're telling you to cite case law. So what case law are you aware of when it comes to the issue of prosecution? And again, who is the one to request for extradition? Which is the requesting state in this regard? Yeah. And which state is extraditing? And remember, they're asking you advise the DPP. Is it the work of the DPP to request for this people to be extradited, or is it done through the office of the AG? Yeah. So also look for case law. I think there's a case law for, I'm forgetting, but there's so much case law on extradition in Kenya. A common one is the one for, I don't want to say Akasha, there's this one.
The Chris Okemo case, for instance.
Thank you. Yes, that's actually the case. Chris Okemo, sorry. Chris Okemo is the case. So you can look at it and also try to see, is it the work of the DPP to request, or is it the work of the AG? Yeah, there's also that distinction. We need to know that if the AG, through the office of the AG does this, then the DPP is now to forward it and even to prosecute in court. Yeah. So I wouldn't comment so much on that, but before I close this question, I will also do what? Welcome, Bernard. I've seen your hand is up. Please say something.
Oh, okay. I don't know. I wanted to say that extradition is a special procedure, and I'm guided by I'm guided by the criminal procedure bench book. It's well explained there. And basically is among the other procedures, including which ones? Among the other special procedures that that involve, including inquests and the rest. And through the Supreme Court ruling in Chris Okemo and Gishuru, the Supreme Court gave an advisory that it's now incumbent on the DPP to carry on the extradition procedures on behalf of the government, and through various sources. Again, it has been explained that the requesting state is the one that is looking for the fugitive. In this case, from our question, let me check who would likely be. Janu would be the fugitive in this case, and President Tan Tun's country would be the requesting state, and definitely Kenya will be, the state that will respond to the request from President Tan Tun's government. And so this is purely domesticated within the Office of the Director of Prosecutions. And I think we can get more insights through that Chris Okemo case. Thank you.
Thank you very much. And even if any of you to forget anything about extradition, please go and just refer to the Chris Okemo case. It has really key aspects, especially when it comes to extradition. Yeah. And of course, I think from that case also you'll be able to see and guide the DPP as required in this scenario. I think without any much ado, I don't know, Ben, if you want to say something else, or because I'm seeing your hand is still up.
Oh, okay. I wanted to lower my hand, but at the same time, I was just checking through my notes. Usually, extradition comes with some conditions, and those conditions, I think, usually, I'm trying just to get somewhere. I had written some of the conditions that the DPP, the requesting state, must also indicate the offenses that they are looking for the fugitive, and those offenses must be probably on both sides of the country, must be seen to be criminal in nature, so that from the laws of the requesting state and the laws of the country that is supposed to respond, which I've forgotten the technical name, those must both be seen through the lens of a criminal offense. And the exception to it must be that some of these allegations must not be political in nature. And I'm going to share on the chat the other condition that must be met for that extradition to be seen to be also fair and probably easy to implement. And of course, as you've said, there must be also diplomatic courtesies that must exist between those two nations. And that's why most of these states you'll find maybe the country that Janu has ran to, and Tan Tun's country probably have diplomatic courtesies that can be able to facilitate such kind of an arrangement. Thank you.
Yeah, many thanks for those contributions. Please take note of that. Now, without much ado, I'll move to question 5. I don't know if Hezbon is here. Okay, but before I move, I'm seeing Ken. Stan, your hand is up. Please say something before I move to question 5.
I just wanted to keep the technical term. It is double criminality, in the sense that the offense is both an offense in the requesting state and in the extraditing state. Thank you.
Thank you very much for that. Please take note of that also. Thank you so much. So we'll move to question 5. Maybe I'll request someone to read for us. Question 5. Anyone? So that we can at least finish by 11:30. Anyone? Question 5.
I can read. I can read again. Question 5. Goodlife, a famous public figure in the Republic of Kenya, had an illicit affair with a socialite girlfriend, Queen Sally. He was so fond of her that in his drunken stupor, he would indicate that he was willing to do anything to make her happy. Unknown to Goodlife, Queen Sally was a drug peddler wanted by the United States of America on charges of trafficking narcotics in Mombasa County. On several occasions, Goodlife sent fare amounting to 2 million Kenya shillings to Queen Sally for trips to Nairobi and Masai Mara. While on a trip to Diani, Queen Sally discovered that Goodlife had accumulated about 2 billion Kenya shillings in his bank account. She was able to secure the password to his account and transferred 500 million Kenya shillings into an account in Uganda. She disappeared in the pretext of a sick mother and could not be traced. Goodlife was able to locate her in Uganda, having a good time with her Tanzanian boyfriend. He reported the matter to the Banking Fraud Unit for investigations. The investigators, through the informal channels, managed to convince her to return to Kenya for a bigger and more lucrative deal. On arrival at Jomo Kenyatta International Airport, she was accosted by the investigators from Banking Fraud Unit, who arrested her and detained her at JKIA police station. You have learned from the investigating officer that they intend to arraign her in court to face charges of obtaining by false pretense, contrary to section 313 of the Penal Code, among others, and that bail will be opposed by the state since she has been out of the jurisdiction of the court for long. Her partners in the drug trafficking business have heard that you are a hot-shot lawyer who has ability to secure her freedom. Evaluating the relevant provisions of statutory provisions, case law, and legal principles, develop an appropriate strategy you will use to secure your client's freedom pending trial.
Thank you very much for that. So, what do you think this question was on? Anyone? Let's move a bit fast.
The question was on bail pending trial. Actually, that's what it's trying to test on. The grounds for bail, why a court may deny bail, and such.
Good. So yeah, it was on bail pending trial. So of course you begin by quoting maybe the legal provisions is Article 49, which speaks to right to bail. Now remember it's pending. Article 49, and also you also need to give case law. And lastly, even why the principles that the court look at when they are granting bail. So all that you need to have. Now, one thing that I need to point out here, I don't know while you're revising, this is something that has just come to my mind. While you're revising most of the criminal litigation papers, you'll never miss out something on bail. Now, there's always this question that maybe discuss factors that the court takes into consideration before granting bail. And then there's a question that also says, discuss the principles that guide the court while granting bail. I want to tell you these are two different questions. There's one that is testing factors, and there's one that is testing principles. So when you see such a question, please don't be quick to, when you ask principles, don't be quick to give factors. And when you're asked factors, please, sorry. And when you are, sorry for that, my apologies for that. And when you're asked factors, please don't be quick to give principles. These are different, yeah. So again, when you find a question on bail, please look out for such. Sorry for that. I had to mute so that you could not hear the noise in my background. But anyway, this question was basically testing the issues that we know about bail. And please, such a question, you only get marks when you not only give the principles, but also try to marry the principles with the facts as they are on the paper. So anyone else who wants to contribute more on this, the floor is open before we move to question 6. Yes, Anyona Oscar.
Yes, thank you. On my part, I would start a bit back. I mean, a bit far. I'll start from, because this guy is held at the police station and they have not been arraigned in court yet. So I'll perhaps start from going to the police station and try to secure a police bail or police bond for them before they're actually arraigned to court. So once that is successful, then they'll be given a date to appear in court. And then in court, they'll take plea. And then after that, now I'll start discussing bail. And I'll actually say that bail being an automatic right of an accused person, there's no requirement for me to make a formal application. I'll just make an oral application in court. Of course, I'll cite the legal principles and the constitution as applicable. And it will be upon the prosecution to oppose bail application. But for me, I do not think that I need a formal application for that.
Okay, thank you very much for your reaction. I agree with you. The application for bail is actually made orally in court, yeah, like spot on, after somebody has pleaded guilty or not guilty, yeah. No, wait, yeah, not guilty mostly. So, in that regard, I also agree with you that where you've started, but I really want to hear, just not giving us what you have done, but also this issue of bail, because remember, they've already been brought to court. I hear you. Oh, they're still at the police station. Yeah. Again, it's bail, because remember, we have types of bail. We have bail pending trial, we have bail pending appeal, and we have, I'm forgetting the other one, anticipatory bail. But this one here, the one that is applying here is pending trial. Yeah. Which mostly is, it is given before you face the trial process in court. So I think what we are saying is, please know the principles and also try to see how the principles match to your scenario. Yeah, again, to get those 10 marks. Remember, when the question is on develop an appropriate strategy. So as we are arguing, apply for bail pending trial. And of course, you give the principles and even case law around that. Any other person would like to give another reaction to that question before we move to question 6? Are you satisfied with what we've discussed in question 5? Okay, good. So let's move to question 6. Anyone who would like to read for us? This is the last question. Sinjero David, yes, Sinjero.
Yeah, thank you. Reading question 6. A demonstration organized by Unga Revolution, a coconut governmental organization, over the high cost of living turned violent, leading to the intervention of police on 20th December 2022. As a result of the police intervention, over 20 demonstrators were arrested in downtown Nairobi and bundled into police cars. Most of the demonstrators who were arrested were later released without charge, and 2 were charged at Milimani Law Courts for unlawfully damaging buildings contrary to Section 86 of the Penal Code, Cap 63 of the laws of Kenya. Kiombo Okiomeri, the leader of the demonstration, who was among those charged, was, however, neither charged nor released more than 24 hours since he was last seen being bundled into police car, registration GKX 911. The Daily Gossip, a nationwide newspaper, contained a photo of Kiombo Okiomeri being bundled into the police car in its publication a day after the riots, or with headline, "Police break violent food protest." The family of Kiombo Okiomeri, in efforts to trace his whereabouts, has visited all police stations in Nairobi and nearby counties to no avail. It has now been more than a month since Kiombo Okiomeri was arrested, but the police have officially denied having him in custody through a letter by the regional commander, Nairobi County. Abu Kiombo Okiomeri's father, has now retained you to file necessary application in court to help find his son. Draft the application. 10 marks.
Thank you very much for that. Anyone who wants to give their contribution on that? Maybe first of all, tell us maybe which topic they think that question is testing, and maybe now what type of application you need. Yes, Mukuna Njeri. Sorry. But maybe
Question, can you hear me?
Yeah.
Yeah, the question is testing our knowledge on the rate of is it usually habeas corpus or habeas corpus? That one. So it is requiring us to make an application to get this missing person, or to require this missing person to be brought, either to be prosecuted or to be released if there is no legal issue holding him in police cell. So in response to your question, it requires our knowledge on the writ of habeas corpus and how the application is made before court.
Thank you. And also say hi to the young lawyer behind the scenes who had the voice. Yes, this is a writ of habeas corpus that you're required to draft. Now, what does the application entail? What kind of documents should you be drafting? Anyone? Yes, I don't want to choose Charity. Let me see the others. It's not because I know you'll give a wrong answer, but because I want others to speak. Let me just see. Sifunjo Award.
I thank you. I believe we will draft one, a certificate of urgency, and 2 will draft a chamber summons, and 3 will draft a supporting affidavit.
Okay, thank you. A follow-up question. Why do you think we'll draft a certificate of urgency?
Okay, in my estimation, there's a continuing gross violation of the individual's right under Article 50 of the Constitution, and keeping on holding him there will amount to a continuous violation of that right. And moreover, you do not know if he's alive, if he's dead, so you want him produced urgently before court.
Thank you for that. Now, that's true. I agree with you. And also remember, you're required to be, if you've been arrested, you ought to be brought in court as soon as possible within the constitutional timelines. Remember, he was arrested on the 22nd, so 20th of December, and it was more than 10 hours, and we can't really tell where he is. So yeah, there's a problem there. That's why we need a certificate of urgency. And I want to know, because the marks here, it's enough to know it's a certificate of urgency. It's enough also to know that chamber summons, but also we need to know the format. And thank you. This means I've seen some reaction on the chat. I think it's important. I think one of you is saying it's a award that says the right to habeas corpus is an absolute right under Article 25. So it shouldn't be limited. Yeah, it's an underogable right. Now, anyone who had drafted a chamber summons or even certificate of urgency. Also remember, always be giving enabling provisions. Yeah, like always cite the laws that speak to these issues. Like if it's not the habeas corpus with article, I think 50 or 51, I can't recall. Also article 25 B, B or D. Yeah, anyway, who had drafted this chamber summons or even certificate of urgency and wants to do what? To give us feedback on that. Yeah, I think I'll choose Anyona Oscar, then we can have Main Charity.
Yes, thank you, Senior. So I hadn't really drafted anything, but I've heard my sister say that we're supposed to draft a chamber summons application. And I was worried because I found a case by Justice Lesit. The case of, I'm going to type in the chat, where she said that applications seeking orders of habeas corpus or habeas corpus, depending on where you're logged in from, are supposed to be made to the court by way of petition, because it involves enforcement of Article 25 of the Constitution, and being it's a constitutional right, then you're supposed to approach the court by way of constitutional petition. So in that application, the application in that case for habeas corpus was made under, using the chamber summons, and actually the court dismissed the application and ordered the party to do a petition instead of a chamber summons. But I can see from this paper, the highly scored candidate did a chamber summons and scored full marks. So you may want to advise on that, whether it is a petition or chamber summons.
Just a minute. I just want to pick your brain. You've said that the court said that the applicant should petition. Just read that statement by
Yes, the court. Yes, the court ordered the applicant to do a petition instead of the chamber summons, because this matter involves enforcement of Article 25 of the Constitution. Yes.
May I interject on that particular case?
Yeah, sure.
Thank you. The case you Anyona is referring to is the case of Fosia Ahmed by Yusuf versus the DPP and Buruburu Children's Home, I think, who was an interested party. And in this case, it involved a minor of 16 or 17 years old who had been married off by the mother after the father had abandoned the family. So she was married off to a 54-year-old. And so subsequently, the DCI arrested her and kept her in custody. So when the father reported the matter to the police, I think that is when they arrested her. And therefore, I think Ahmed Nassin was the counsel on record through another advocate holding brief. So in my reading of that case, when I saw the issues that were being interrogated, Justice Nassit was of the opinion that it is important to have to interrogate the issues that were being raised, but also the respondents' counsel to have and made some opposition, and therefore it was important to interrogate those issues that were being raised. And according to Justice Nassit, it was these witnesses needed. The minor needed to be produced and be asked questions to verify their ascertainment or to ascertain the averment that were being made. And therefore, in our opinion, the case ought to have been filed through a petition, just like Mr. Anyona is saying. I am not sure whether she dismissed the application. However, she directed the petition to be filed in court so that the both parties can be heard. I think that was as much as I remember about that particular case of Bayusuf, Fosia Bayusuf.
Okay, thank you also for your reactions. Maybe I would love to hear from Ado Sharon.
Okay, mine was actually a question. I don't know if I should just ask it now. So, okay, so Yes. So, okay, I know that what you're supposed to go with is the habeas corpus writ in this particular question. But I was going through a certain article, and then I saw that they were saying that for one to raise a writ of the habeas corpus, then you have to confirm that the police really has the possession of whoever is being held. But in this particular case, the facts that we have, the police had written a letter that they do not have the suspect in their possession. So I don't know how we go about that.
Just to respond to you, remember the police will always refuse these things. I mean, you can't be the one who is holding me. They're saying, in fact, I have them, or rather, I have you. No, the police will always refuse these claims and say, no, you don't have the person. That's why in your chamber summons, and I think this chamber summons was supporting affidavit, to try to say that indeed they were last seen with the police, so they are within the police custody. So the police writing a letter does not really show that you're not sure of what you're saying, but it's them refusing. So it's their word against yours. Yeah.
Thank you. Thank you.
Yeah, then just to respond to what has been raised before, I think we go with chamber summons because that is what we marked last year. But I will also be happy to read the decision by Justice Lesit to just see what was said. But before maybe I proceed, I don't know, Anyona, Oscar, or Sifunjo. Yeah, I think, no, let's do Barak. Then we can do Anyona, then Sifunjo. So Barak, Anyona, then Sifunjo, in that order.
Yes, I think today, is it yesterday? No, I think today morning, we were in a class where the lecturer actually clarified something that I found was intriguing and important, that a court can make a pronouncement, but where something is provided for in the statute, then unless the court has declared it unconstitutional, then what the court rules or the opinion of the court may not override the statutory provisions. So you find that statutes, even though Justice Lesit may have made those observations, but what does the statute, or what do statutes provide? If you look at section 389 of the CPC, it's actually chamber summons ex parte. If you look at now the rules that govern habeas corpus proceedings, again, it says it's chamber summons and supporting affidavit. So I believe in as much as the court may be saying something, but until these laws are declared unconstitutional, then they will remain and they will probably override what court pronouncements are. For those cases sometimes should be distinguished. I think that was my opinion. So I would also go for chamber summons.
Thank you very much for that observation, even for that comment. And I think we're on the right track. And given that there's even a legal provision which the court is yet to declare unconstitutional, let's go with that court. Then we move to Anyona. Then Sifunjo is Anyona.
Perhaps I could just proceed, Rispa.
Please do, yes. Sifunjo.
Oh, okay, thank you. So what I was about to say is that I think it's Hesbon who mentioned it, that in the exam room, the examiner will always guide you. So you see, if you look at that question, what you're required to file is actually an application. And so I think if in the mind of the examiner, he doesn't want you to come up with a pleading. So maybe if he would have said draft the necessary pleadings, then you'd go the petition because that's a pleading. But then if he tells you to draft an application, then I don't think you can draft a petition in place of an application. The only proper then response to that question would be you draft a chamber summon application accompanied by a supporting affidavit. So mine is just to re-emphasize on reading the question and looking at what exactly the examiner is perhaps looking for in that particular question.
Thank you for that observation. And actually, that's also a strategy. Thanks for that. I hope it has cleared just not knowing the law, but also knowing strategy, how to apply strategy. So I hope that has helped to know that indeed we are required to draft a chamber summons and a petition. And anyway, the law clearly says it should be a chamber summons. So please take that into account. Then anyone who has thought of a chamber summons, I want us to end this. Anyone who had drafted, or even the format, anyone format, tell it habeas corpus.
I can read one for a similar case that I drafted.
Let's just a minute. Let me give Weyusia Shivuye to say something, then now you can take it over. Oh, sorry, Weyusia, then Barak, then you. I hope they can do that in the next 15 minutes that we can finish. But anyway, Weyusia, it's over to you. Over to you.
Okay, so thank you. Actually, it's not very easy, but anyway, so I have a question, but before then, let me respond to the question that you posed. So how to draft a chamber summons? Of course, you'll have the citation, the caption of the court, which in this case, you're making to the High Court. It is a miscellaneous application. And then you have the parties. And regarding the parties, I have a question, but I'll come to that later. So I know for the respondents, we'll have the Inspector General of the Police, we'll have the DPP, we'll have the AG as the respondents. But for the applicants, the applicant is where I have a question, because I was in a discussion whereby people were saying that the applicant should be the person who is missing, and others were saying the applicant should be the person who was approached to, because when you look at the supporting affidavits, you need someone to swear the affidavit, and it should be someone who is present so that they can swear the affidavit. So maybe I'll need guidance on that. But after that, now on the enabling provisions of the law, we start with the Constitution, Article 25, then we'll have Article 50. Then you can maybe invoke the jurisdiction of the High Court, Article 165. And then you talk about the provisions under the CPC. Those are the enabling provisions of the law that I can remember at the moment. And then chamber summons. And then the caption normally starts with let all parties concerned. So the grounds, as I think someone mentioned, if we bring under certificate of urgency, then the first prayer should be the matter to be certified urgent. And then now one of the prayers is that the court issue an order that that person be produced before court, and if they are not charged, then they should be released. Then, of course, now for your grounds, you give the story that is given in the facts that maybe the person was seen being bundled into a police car. He was arrested among other people who've been released, and those people, and this person in this case has not been released, and there is a reason to believe that they are in police custody. And also in the supporting affidavit, then one thing I think I'll mention is the issue of that magazine, that newspaper that had a headline that that contained a photo where the Kiombo was being bundled into a police car. So maybe I can attach that one, and also the letter from the police that they were claiming that they did not have that person in custody. So that is how I will do it. So my question is, who is the applicant in this case? Maybe if I get guidance on this. Thank you.
First of all, thank you for your contribution, and I agree with you with all that you've said. And in response to your question, the applicant here is the relative, or the one who goes to initiate this process is the relative or even the spouse, depends. Like in our situation here, it is Abu Kiombo, that is the father to the person who had been detained. So he'll be the one who will be applying, or rather filing the application. So that in the supporting affidavit, he says, I, blah, 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 fathered or to, Kiombo, somebody. So the applicant here is Abu Kiombo. I hope that's clear.
Yes, thank you. Thank you.
Okay. So I think now we'll hear from Barak Hamir. Sorry, okay, Barak, then Bernard, then David, when we finish. So Barak, over to you.
Yes, I mean, I concur with counsel who's just spoken, and also I associate with your wisdom. Maybe just to add, I think she captured all that I heard. Maybe I've seen also that in the caption, they usually indicate the kind of application is miscellaneous application. And then in the matter of articles 25D 49.1 and 165.3b of the Constitution of Kenya, and in the matter of section 389 of the Criminal Procedure Code, and in the matter of criminal procedure rules, directions in the nature of habeas corpus, and then in the matter of an application for directions in nature of habeas corpus. Now, in terms of applicant, I agree with you, but what I've also observed is that it's written as in respect of instead of the relative's name. So maybe you can clarify that. Like in this case, we'll say the applicant is in respect of Kiombo Kiomeri. That's what I would add. And of course, it's chamber summons as we've agreed. And the others, I'm in agreement. Of course, at the end of it is dated and at Nairobi, this day of today, of the advocate, Barak, and then drawn by Barak and Sifunjo, advocates, to be served upon Inspector General of Police and the Director of Public Prosecutions. Thank you.
Thank you for your contribution. Just to ask, will you kindly just send a photo of what you're saying in respect of? Yeah. Will you send a photo on the group or somewhere? Yeah. I've also seen somebody requesting for that. Then you can listen to Ben, then Jerry will finish for us.
Thank you. I was working hard to unmute. In the interest of time, I think we wanted to add Article 51(2). I hope it hasn't been mentioned. Article 51(2). A person who has been detained in custody is entitled to petition for an order of habeas corpus. Then, in general, on the applicant, we were told that somewhere that usually the applicant is anyone who can certainly give a supporting affidavit. So wherever there is the way my learned colleague was asking about the applicant, probably even without regarding this specific scenario, I would always put it in my mind that An applicant will be any interested party. In this case, someone who can be found and who can give a supporting affidavit. Thank you.
Thank you for those meaningful contributions from you, Ben. I think we can finish with who left.
No, actually, I'm here.
Oh, okay, please, yeah, thank you. Please give your contributions.
Thank you. And now that everything has been said, I do not wish to belabor. Maybe I pray for you, but I mean for us. But I just wanted to seek your mind on something, or to pick your mind on the issue of the applicant as was raised by Weyusia. I have under school of thought that says that you can include the person being detained as an applicant. I don't know what your take is on that. Among other applicants, that is.
Okay, now my simple question will be, sorry that I'm responding to your question with a question. Will this applicant be able to swear a supportive affidavit? Remember, they're even indoors, sorry, not indoors, in custody, not indoors, sorry for that.
And definitely they will not be able to swear an affidavit. And that is why I said I have hand of it somewhere. So I wanted to pick your mind on that.
Where? Maybe what is the source? Because again, it's good even to have access. Maybe you say in practice is what I've been seeing. Yeah, you know. Yeah. So you know, hearing is one thing, and what happens on the ground is another thing. Have you seen it in practice? Because I know, even from what we drafted, because I did this question, habeas corpus, and I think I had done a bit of practice. So that's the way we've been discussing, that if anyone who can be found, most probably even the one who went and reported that this guy is missing, yeah, and even the one who understands the circumstances. Now in our scenario here is the father. It could be even the spouse, yeah, even a friend. It could even be an uncle. Like I think there was another exam question that was it was more of the wife of somebody who had been detained. So the wife of the applicant. Yeah. So I still argue that the applicant here isn't the person being detained, but the person who is a close person to the other one who's being detained. Rather, who understands the circumstances. I hope that helps.
Very much so. And I'm well guided. Thank you.
Thank you too for your questions. So at this juncture, that was criminal litigation 2023. The other task that I want you guys to do, I hope you've seen the topics which were tested. I know private prosecution was not tested, and I think inquest, they normally interchange. But just to remind you, please, at least over and above knowing bail, bond, what else? Issues of charges, which is very key. Yeah. Please also know these last topics. That's really also important. They can give you 10 marks if you understand these topics. And of course, if you understand your course outline. Otherwise, thank you for having me. I think we'll end with a word of prayer if there is no further questions from you guys. But if there is, I'm happy to hear before we close at 11:30. I know we are tired, we're exhausted, but I love the spirit. Please keep going. They say it is always dusk before dawn. I know for most, if not all of us, we feel like we're in our dusk moment, like it's so dark. We feel tired, we feel exhausted, but keep on keeping on. Because once November is here, within no time, I think, which February is here, you will be reaping the fruit of your labor. Just keep on keeping on. I know it can get tough at times. Feel like you're not confident, but please, I'm here to encourage you. I was also there, and I managed 9 pleas at first instance. And I know we can all get it. Beginning with criminal litigation. Please don't despise any unit and say this is a walkover, because you might get into that exam room and you see the question there and you're like, this clearly wasn't a walkover. So please prepare adequately. We are here to help you. Please reach out in case you have a question, we discuss something. And let me just also tell you, from even sitting and discussing this paper with you guys, I did this paper in March. And clearly, let me tell you, there are things you guys are telling me that I never knew as I was sitting for that paper. You can imagine. I don't want to say it is damage already done with damage control, but I hope you see the value of such discussions. Yeah? And I'm like, if I had had such a sitting with people, of course not to discuss at the level which is coming, but just to have such ideas, I think I'll maybe have performed better. I got an A in criminal litigation for my transcript, but I think I will have performed better. Just to encourage you that there is a lot of power in discussions, a lot of power in sharing. Yeah. No one knows so much that they cannot get another thing from someone else. And no one knows too little that they cannot even teach or even share anything they have with another person. Remind yourself that. Otherwise, I'd like to end it here. Thank you for having me. Thank you for listening to me. I hope I was not boring. I hope you've have been of help today. Even as you sleep, you will think about habeas corpus, bail and bond, all those things you've said today. And any other thing that was in the first outline which was not tested. So I'll pray, then we'll finish. Dear Lord, we thank you and we bless you. Thank you for the gift of life. Thank you because, dear Lord, you're faithful. Thank you for the class of individuals. May you make them at their points of need. May you guide them. May you bless them. May you remember them, my Father. I pray that even as they rest this evening, you'll give them peace of mind. You'll give them a restful night. And even as they see, as we see the morning of tomorrow, we'll be careful to give thanks to you. Lord, we thank you and we bless you. This is our prayer, faith through Christ our Savior. Amen. Good night and thank you for joining. See you next week. Bye.
Thank you so much.
Bye.
Good night.
Bye.
Good night. Thank you.
Jerry, your hand is up. Jerry?
That was inadvertent. My apologies. Good night.
Thank you. Good night. Right. Let me see if I can stop the recording. Stop recording.
Thank you.
Okay.